John Hafetz is going to be talking about the al-Marri case, which raises the critically important question about who may properly be designated as an enemy combatant and held in military detention, and who has to be tried within the criminal courts of the United States. Mr. al-Marri is the only person now being held as an enemy combatant within the United States. He's being held in South Carolina, and he was, as John will explain, arrested and detained in Illinois, was on his way to a criminal trial when the government chose to redesignate him as an enemy combatant.
The import of this question, I think, is really self-evident. If someone like al-Marri can be detained as an enemy combatant, though the allegations against him are severe, there's really no limit to who can be subjected to indefinite military detention within the United States. The case is effectively a crossing of what I would call a constitutional Rubicon. Once you've allowed the executive to detain people indefinitely because he labels them suspected enemies, affiliated with terrorist organizations, perhaps plotting terrorist acts, there's really no limiting principle. And the whole tradition of civilian supremacy and the principle of the right to criminal process for those accused of wrongdoing is swallowed up by the specter of military detention power.
That's a different question than what you do with people who are carrying rifles and shooting at U.S. forces on an active battlefield. We have never had a system of criminal preventive detention in this country, and I don't think that this is the occasion to begin.